A $4 billion typo and an impending legal brawl that no one is talking about enough.
Things are looking pretty odd for ride-sharing companies.
So yesterday, Lyft announced its projected earnings statement for shareholders.
Remember, Lyft is a public company.
And in the initial press release,
Announced it was expecting an increase in profit margins of 500 basis points, which, y'all, is literally wild.
Basis point is basically a fancy way of saying 1/100th of a percentage.
So 500 basis points was a predicted growth on margins of 5%.
So within minutes, the stock price for Lyft nearly doubled.
Meaning, in the most simple terms, that Lyft's market value was basically almost double. Let's call it from about $5 billion to $9 billion.
And then about an hour later, Lyft's CFO got on a call with analysts and was like, hey, about that 500,
It's actually not 500. It's 50.
That's right, they added an extra zero, which means it wasn't a 5% expectation, it was a 0.5%. But if a picture is worth 1,000 words, then a typo of a zero is worth $4 billion.
But hey, maybe I don't entirely blame, because Lyft, Uber, and other ride-based companies like DoorDash
should soon be facing massive legal changes that could affect many of you. And a lot of this has gone way too far under the radar for how important it could be. Last month, the US Department of Labor, or DOL, issued its final rule for how individuals should be classified as either workers or independent contractors. And aside from probably hearing those terms all the time, especially during tax season, how you are classified as either an employee or an independent contractor has a massive effect on things like benefits or insurance, sick leave, maternity leave, PTO, and it's about to get very complicated. See, up until 2021,
the DOL's guidance for courts on how to adjudicate these issues was known as what's called the economic realities test.
It was a 5-factor test, and courts were supposed to use it to look holistically at the situation of a worker
and then determine how that worker should be classified.
Those 5 factors were the degree of control exercised by the employer over the worker, worker's opportunity for profit or loss and investment in the company, degree of skill and independent initiative required to perform the work, permanence or duration of the working relationship, and the extent to which the work is an integral part of the employer's business.
And these 5 factors resulted in a lot of successful disputes for workers who were classified as independent contractors but thought that they should instead be classified as employees.
In 2021, that test was reversed and replaced with a weighted test. Same 5 factors, but
the DOL guidance told courts to focus primarily on 2 of them. Number 1, the degree and control over the work, and number 2, the opportunity for profit or loss.
And this resulted in many favorable decisions for the employers who wanted to classify workers as independent contractors, not as employees. Because from a basic economic standpoint, it saves employers a lot of money. But for many workers, is not awesome. Last month, the DOL's new final rule did something pretty interesting. Rescinded that 2021 change and reinstalled the 5-factor test. Kind of. Because it also did 2 things that seem kind of small, but could potentially be massive for many of these companies and for you. It carved out a 6th factor that basically took the investment portion of the 5 factors test and made it its own factor.
Specifically, whether any investments made by the worker are entrepreneurial.
Why is that important? Well, remember, independent contractors are generally seen as entrepreneurs because you have the ability, in theory, to be able to take as many jobs as you want. Under this new factor, costs incurred by a worker in order to perform a specific job, its tools, equipment, etc., will likely not be evidence of entrepreneurship, meaning they might indicate employee status,
versus costs that serve a business-like function,
such as increasing the worker's ability to do more types of work or expand their market reach, likely will be evidence of an independent contractor status.
And the question might become, for instance, what is a car? Is it more like an operating expense to be able to perform the specific job of ride-sharing responsibilities?
Or is it more like a capital or entrepreneurial expense to allow the worker to do a lot more things in a lot bigger market?
And if that wasn't tricky enough to decide, there is one other change that I think is going to be even bigger.
It's not being talked about a ton because it was not put forth as an actual factor. However, the final rule ends up clarifying the one factor that most courts seem to say this is what we really care about as an initial test.
And that is the nature and degree of control over the performance of the work.
The rule states that in looking at this factor, a court should also consider whether the employer sets the worker's schedule, whether the employer supervises or has the right to supervise or discipline a worker, whether the employer limits the worker's ability to work at other places, whether the employer uses technology as a means of supervision, and or whether the employer controls the marketing of services or the price of services.
And this one could be massive, depending on how much weight courts put on it. Because if you've ever driven for one of these companies, then you know that you don't set your own rate.
Most relationships in the gig economy don't involve setting your own rate. And if that question becomes instrumental in deciding whether someone is actually an employee instead of an independent contractor, that could have a huge impact on millions of people and the companies. And it'll be interesting to see how this plays out before it's supposed to go into effect next month.
Because yes, Lyft and Uber and many others have put out statements saying that this new rule doesn't affect how they're going to operate or how they should classify people at all.
Yet, at odds with that is the time, money, and resources that all of these companies put into fighting this new rule.
It seems like no matter what, something's got to give, 100% for sure, or at least 1,000%, or 10% really, depending on which zero is accidentally added or